Hey, this is Jamie from Green River Ordnance. You're listening to Lone Star Community Radio on 104.5 KCZW LP Conroe and 106.1 KZCC LP Conroe and worldwide on irlonestar.com.
Good afternoon and welcome to the Legal Connection Show with Toni and Cheryl. We are Conroe's FM on stations 104.5 and 106.1, and you can listen to us live on irlonestar.com/TLC. My name is Cheryl Ellsworth Jahani, and I'm the Cheryl part of Toni and Cheryl, and I want to introduce you to Toni Sherence Collins. How are you doing today, Toni?
I'm fine. You did that very well. I'm impressed.
Thank you.
So I guess I'll pick up where you left off here. This is the Legal Connection Show, and the first one we've aired. And this show is actually a public service for when people have questions, legal questions, and they feel like they need help, and they don't even know what direction to go. We're the Legal Connection, and we're going to give you a little TLC with that. That's Toni Lynn Collins. That's the Legal Connection. It's the Learning Channel. I mean, any way you want to go about it, we're here to basically answer your questions to the extent that we can. Now, we have a website, and you can you can ask your questions that you may have on our website. There's a facility to do that, and the website itself is www.legalconnectionshow.com, and there's a place where you can direct your questions that you can toggle. It's questions at legalconnectionshow.com. If you write your legal questions in, we will do our best to answer them. But remember, this to give you a little disclaimer, we're not your attorney. We are simply a show that we're both attorneys.
Yes,
both
we're
Cheryl,
two attorneys.
Cheryl and I are both licensed attorneys. I've been licensed since 2002, and Cheryl's been licensed a little bit shorter period than that. We're trial attorneys. We do pretty much the full gamut of the law, and most of the, a lot of the questions you'll have will be generic that we'll cover for each show, depending on what kind of questions we get for that week. Today's show, we're going to cover wills, estates, things that you have to take care of in your own life that maybe you don't want to think about because, death is not something all of us like to face, but it's reality and it's going to happen to all of us. So you have to kind of be prepared for that. We had kind of tossed around what our first show would be on, just so we kind of get a hook, so we'd get a lot of people that might be interested in, listening.
Right, and I just want to reiterate too that this is a public service for you guys, and we're in Conroe and Montgomery County, and we're here just to answer your questions. And like Toni said, if you have any questions that you want us to specifically speak on, email those to us. But right now, like Toni's saying, we want to go into our topic, wills, and any probate type transfers. We're going to explain to you what those are. And
well, we've already had some questions on our website, and we have the answers to those. And they're just going to be the type of questions that many people will have in general that just don't really know a lot about it. And people will have questions about wills as early as, they're thinking about it, maybe 10 years old, and all the way up to, I guess, life expectancy. And I know the oldest living person, to my knowledge right now, is about 114. And they're called super centenarians. And we actually have one in Fort Bend County, a lady, and she was driving up until the time she was, I believe, 98 years old. She's the longest living licensed driver.
How wonderful.
And there's also another guy that lives in Austin. There's only one male out of the top 15 super centenarians. But these people may already have, with having been alive so long, created some sort of estate control with an attorney, or maybe not. Maybe they don't have anything left at this age, and they've done the right thing, and so they're going to head on out of life with a bottle of wine sliding into the grave and nothing in their bank account, which is probably the way we should all do it. But at any rate, we're going to just answer some questions on wills. Again, our topics are going to be very broad in the future. They will run the gambit from DWIs to murders to simple questions about contracts. I'm a landman, do oil and gas work, so I know, for the last 25 years I did title. I know a lot about that. I'm also a licensed real estate broker, so kind of dabbled in that for a number of years. Between Cheryl and I think we have, about 100, at least 100 years of life experience between
Right,
us.
that's true.
And children and marriages. We'll do a lot of, we'll answer a lot of questions on child custody and divorces and the things that are a lot of people kind of touch on in their daily lives that people need questions answered on. But today we are going to do wills and probate.
Right, and so let me give just a little bit of background about wills and why we do that. We're one of in other countries, it's very common that they don't let you, the government will not let you pass down your property. They went upon death, property escheats. We call it escheats. It's ESCHEAT. It escheats to the government. But in America, we have a statutory right to pass down property to our descendants, our heirs, those people that we decide at the time of death. And so that creates the whole issue of what will we do with the property that we've accumulated, maybe our ancestors have accumulated during our life at the time of our death. Where will that property go? And so we have two ways to do that. We have statutory intestacy laws, which are default laws if you don't have a will or you're not passing property through a non-probate transfer, like a life insurance policy or joint tenancy title, joint title to a home. Then we have some statutory laws. Those are default laws. We don't really want to use those. We prefer deciding where our property will go ourselves and in what proportion, right? And so we've got probate property that's passed through probate under the will, and then we've got intestacy, which is non-probate property, which means you didn't have a will. So,
but see, you're talking about all this kind of detailed law book type of stuff, and right now I'm sure that everybody's sort of like rolling over in their grave right now, just thinking this is really so boring. The crux of the matter is, if you're like Cheryl and I, or Anna Nicole Smith, or anybody else that's sort of out there
Hugh Hefner.
Well, yes, if you're kind of looking at like perhaps some of my friends from years ago, the best way to secure your lot in life, if you don't have a lot of skill sets and you have not won the lotto, is to marry rich. And hopefully you'll inherit.
Right.
And so that was sort of the first direction I would kind of be looking at, not personally, but that's what Anna Nicole Smith did. Of course, look what happened to Anna Nicole Smith.
Right.
She married very well. She was 29. I think she was 29 when she married Howard J. Marshall, or is it J. Howard Marshall? And she ended up really pretty much dying before she got the benefit out of it.
Right.
So that kind of goes to a joke that I'm going to tell that's kind of segue into this. And you may have heard this joke before, and I'm going to tell it really bad.
Okay.
I'm going to say it anyway.
Let's hear it.
Okay. So, I wish I'd written it down. I haven't. This is just going to kind of off the cuff. There was a lady, and she was at her husband's funeral, and she was talking to her really good friend, and her friend was admiring the beautiful ring on her finger. And she said, she goes, well, I have, I don't have a lot of money right now, and I need to try to do something, to find a way to survive now that my husband's passed on. And so I'm just wondering if maybe you could loan me some money. And the lady was looking at her ring saying, well, it's a beautiful stone on your finger. How large is that? And mine actually is 7 carats, but
Oh, it's gorgeous.
Well, thank you. It's just a pretty ring, needless to say. Anyway, so this lady had this ring, and she, the lady says, "Well, you've got a beautiful stone," and she goes, "Oh no, I don't have any money. I had $20,000 that I got in a life insurance policy, but I have no other money. I've already gone through it." She said, "How did you go through it? The funeral's not that big, and there's only a few people here." And she said, "Oh no, the funeral was $5,000, but my memorial stone was $15,000. And she says, "Wow, that is some memorial stone." And she said, "That's right, a full 15,000 right there on my finger." And so, so the bottom line is, life insurance. With that, the life insurance may not be available to get you by. Anna Nicole Smith knew this. She also didn't consider that when she got married to J. Howard Marshall, that he would have sons that
That's
we're going
right.
to put all of the assets of this gazillionaire in an estate so she couldn't tap into it.
Right.
So, so we're going to get a little bit into how estates work, and you know, if all that shiny, like they say, and I think that the country western songs is not gold.
Mm-hmm.
So, so the crux of the matter is perhaps we shouldn't be looking at people for their dollar value when we meet them, like some people do, but we should be.
You mean like you suggested at
Yes,
the beginning of
yes.
this?
Well, like
Okay.
Anna Nicole
Right.
Smith,
Uh-huh.
and we should actually probably do to kind of bear in mind what the best-selling book of all time uh, says, and what its authors kind of show us, and that is that we'll all we're born. I think. Let me quote this. It's from the
That
author.
1
itself.
Timothy 6:17.
Yes, and there's going to be so many more besides that, but 1 Timothy 6:10 says, "For the love of money is a root of all sorts of evil, and some, by longing for it, have wandered away from the faith and pierced themselves with many griefs." And 1 Timothy 6:17 is, "As for the rich in the present age, charge them not to be haughty, nor to set their hopes on the uncertainty of riches, but on God, which riches provide us everything just to enjoy." And the bottom line is, and then I'm just going to go to the one that I want to talk about today, and it's Job 21. He said, "Naked I come from my mother's womb, and naked I will return. There the Lord gives, and the Lord takes away." So the bottom line is, you're going to come to the world with nothing, you're going to leave the world with nothing, and so in between we should do the right thing.
Yeah.
But in the interim, we're going to tell you what the right thing to do is with regard to estates, wills and estates.
Right. Absolutely. So we're here to answer your questions, and this is something that we thought was relevant. So we're, yeah. So Job, naked I came from my mother's womb, and naked I will return there. The Lord gives, and the Lord takes away. It kind of reminds me of that parable in Scripture too, in the New Testament, where the rich man had stored up all of this wealth, and was trusting in those, and was told that you didn't know this, but your life is going to be required of you tonight. And so, what you put your trust in,
I love that verse. I love that whole parable.
right,
Because here he was hoarding all this stuff his entire life.
for security.
And for what?
Yeah.
He was going to go. Oh, he was going to go hopefully to the Lord, and he couldn't
Right.
take it with him. But it's going to stay behind, and we're going to tell you what's going to happen with that property that was left
And
behind.
how to deal with it. That's right. Okay, Tony, thank you. Well, I'm looking forward to our next section. And remember, you can listen to us live on irlonestar.com/TLC, Tuesdays 12 to 1.
Don't forget to download the Lone Star Community Radio app for your Google Play or Apple Store. Bring Montgomery County's community radio with you anywhere with your smartphone or tablet. If you are in the Conroe area, tune in on FM. That is Conroe's FM 104.5, 106.1.
Hispanic Chamber Connections with Dr. Carlos Sanchez, President of the Woodlands Conroe Hispanic Chamber of Commerce, featuring event announcements, member highlights, and more. Tuesdays at 1 p.m., broadcasting from the heart of Conroe, Texas on irlonestar.com and Conroe's FM 104.5, 106.1.
Welcome to the Legal Connection Show with Toni and Cheryl. So today we're talking about wills. And Toni and I are both licensed attorneys in the state of Texas, and we're practicing. We practice all kinds of law, general law. We're trial attorneys, and we felt like, and based on discussion with some of our clients and people in the community, that wills was a good topic for us to talk about today. So, Toni, how do you want to get this started?
Well, I think I'm going to add, just because there's some other stuff that was going on that brought this to our attention, and that was like Tom Petty recently died at 66.
Right.
And I guess like George Harrison, it was George Harrison died at, I think he was 58. And people die untimely deaths, and it comes up so fast. So not only we need to be spiritually ready, to meet our Maker, but we should have our property together and sort of lined up. So because if people's expectations aren't met, that's really when people get frustrated. So if and I know
So
this
true.
in everything. Like anything, if your kids expect a certain thing for dinner, and they have something else, they're probably not going to be too happy if
Right.
it's not what they wanted. So the
Right.
same thing in a sort of a different scale with wills and estates. If people know what to expect, then there's probably not going to be the need for an attorney. If they prepare in advance and they do it properly, then when someone passes away, then they're thought fondly of, and the people that now have inherited their riches also have that memorial, so they're thinking about them. That's why people have their name on buildings and they write songs. Not the only reason, but that's sort of a memorial to them, because just like they say in the Bible, 100 years from now, people are not even going to know we existed unless we leave our mark with a song, or perhaps a legal case, or a building, or something. But it's more than likely 200 years from now that we're not going to be known unless we're like Beethoven and leave something behind. So,
Right.
but it could be with your estate that you can have a little hand in, having some memory of you, and maybe your future family members can, or your your descendants.
descendant.
Yeah, losing my mind here as I'm thinking about it. They could pray for you too, which I'm hoping. 400 years from now, people might even have me. I might not just be like no memory at all.
Right.
But anyway, so that being said, about wills and estates, you're going to give us a little
Brief cap of the law here in
an
Texas.
outline, a roadmap of the different types of ways to establish your estate.
Well, first of all, there are requirements to make a will. The first requirement that you have to make a will is capacity. Capacity is that you are mentally competent to make a will, and also that that's shown by that the natural objects of your bounty, and you're of age. You've got to be 18 years or older. In the military, I know this is probably boring, but it matters. Either married, above 18 years of age, and you have to have the will attested in Texas by 2 witnesses. Those witnesses don't have to be 18 years. They can be 16
And what do you
up,
mean
I
by
believe.
attested?
Attested means they sign your will. You sign the will, and then they sign it saying that in Texas it's the conscious presence test. They didn't watch you sign it, but they were aware, and they were generally in the same room that you are, signing, and they signed when you signed your will, and they know that this was your will.
Right, and it was you had manifested the intent to
Make a will,
put the
exactly.
things in that will and devise to the people that were set or bequeath what was set out in there, your property as set out by those express terms.
Exactly, and the one thing that I would caution you is that if you decided to make your own will, draw your own will up, and didn't go to an attorney and have it attested by 2 witnesses, that you need to make sure that those witnesses are not takers under your will. Like, you wouldn't want to leave your entire property to your daughter and then have your daughter be a witness, because California now holds that there's a rebuttable presumption that if the taker, like for example, your daughter under your will is also one of your witnesses, there's a rebuttable presumption of fraud, that maybe she was up to something.
But we're not in California.
He was up. That's
Do
true.
you have California property?
Did I?
Yeah.
No.
You keep bringing up these worldly things like
Okay,
in somewhere
but for
China.
for example, that same thing holds true in Texas. You don't want your witnesses, your attestators, your attesting witnesses to be takers under your will. Just get someone else.
So really, there is what we learned basically in law school is there's like the will dance. When you actually are putting the will together and finalizing it, there's certain procedures that must be followed, or the will is not valid, and you'll have to. There could be a chance that you will be rolling over in your grave because your stuff is
Right.
not going to go the way you expected.
Right.
It may very well go intestate, which is how the government has decided by legislature that your property should be devised or distributed
Dispersed,
after your death. Now,
Right.
Now that being said, let me ask you this: do you have a will?
Yes, I do.
You have a will?
I do. Do
Wait,
you have a will,
I
Toni?
don't.
Toni?
Because I figure once I'm gone, it really won't matter.
It matters, Toni.
No,
What
it
do you
doesn't.
do in here?
And the way that the Texas legislature has set out the way the property is owned, to me, is sufficient, because I like the way they set it out. It seems to be very fair. The way the laws were set out, I think back in, I can't remember the year that it changed, but I know that when my dad died back in 1986, that when there was a community property, property was owned by a community, meaning that, and we know that we haven't talked about that, but when someone is married and they acquire a property during marriage, there's only certain types of property that are owned as a community ownership.
Right.
And many times a house is owned that way. And I know that when he died, the house that he had with my mother, that it ended up being owned 50% by my mother because he didn't have a will either, and 50% by the kids of that marriage. And of course, he was only married once, and so all of us kids owned half the house. Well, that law changed,
Right.
I want to say in the mid-90s. So now the community property home, which is usually typically the largest, I guess, valued
Holding,
property,
right.
is now owned by fully by the surviving
spouse. Right. As long as the children of the marriage only belong to the surviving
Right.
spouse and the deceased
Right.
spouse.
Otherwise, if it's 50% will go to the community property will remain in the spouse that's still alive, and the other 50% will go to the kids of the other spouse that died.
That's right.
So anyway, but we're not getting into the community. We're not into the marital aspect of it. But the law has changed, and it's kind of important because a lot of people don't know that.
It is important, and it's not intuitive. Like you were saying, I mean, a lot of this stuff, it's not the way we think that it goes when it passes by intestacy, which is why you should have a will. And we need to plot out beforehand, the way we want our property to go. But so we have the requirements to make a will. You've got to be competent, and it's got to be attested to by some credible witnesses that in Texas that's 16 and up, and they don't have to have the same mental competency that the testator, the person actually making the will, does, but they have to, be able to make the will. So
They have to be aware, in other words, that the person making the will is manifesting an intent
Right.
to make a will, and that their intent is to distribute this property upon their death to whoever that they list as set on the term. So being a 16-year-old, you could probably
know what's going on.
know what's going on.
Right.
Uh-huh.
And then now we have notarized wills, too. So those are wills that are signed by two witnesses and notarized, or they can be, the Uniform Property Code talks about signed by two witnesses or just notarized, which I think is interesting.
Now, the notary can actually be a witness.
Right.
I recently had a will probated, and we'll get into that after our break and into the next segment. But the way that the actual will is drawn, whether it's going to be self-authenticating, whether it's notarized, certain things have to be done in order for it to be held to be a legally valid will that can be probated, admitted to probate, and then probated in court.
Right.
Otherwise, you will just not. I guess you'll be up, blank creek.
Well, you'll have to depend on the intestacy laws then,
Right.
and all the whole trouble that you went to create this will won't even
And that
matter.
won't matter to the person that's deceased as much as it will matter
Right.
to the people that
Had
survive
an
and want it.
expectation.
Right.
Well, what about holographic wills?
That is my favorite
So
type
tell
of
us
will.
what those are.
They are completely handwritten by the person before they die,
Right.
and there's certain requirements for it, but it is the easiest will. It is my favorite type of will. I don't think you can go wrong with a holographic will. So you don't have to worry about the way that it's signed. You don't have witnesses. You don't have to worry about pretty much anything. In fact, a holographic will can be one sentence long.
And they stand up in court, don't they?
They stand up in court today. They stood up in court when our state first became a state back in 1830. Actually, we were a republic in 1837. We became a state in 1845. But when the laws were first made in Texas, holographic wills, I believe, were
The thing.
They were the primary type of will because they didn't have, a vast amount of typewriters and printing presses and not your general pioneers and people that were here that were, settling didn't have that type of
So
equipment.
what does a holographic will have to have? It needs to be in writing and signed by the testator. That's the person that's dying,
Yes.
intending to leave. And I don't even think they need to be dated, but I think it's probably a good idea to date it.
I think that I do believe that you need to date it, but we'll get back. We'll talk more about the specifics.
Okay, this is Toni and Cheryl, The Legal Connection.
Lone Star Community Radio presents the Lone Star Radio Troupe. This talented cast will perform radio plays right here in the Lone Star Studios located in downtown Conroe. There will be a new performance every first Sunday of the month. And if you miss the broadcast, just go to Lone Star Community Radio's podcast. or YouTube anytime during that month. Go to ourlonestar.com archives to find the Lone Star Radio Troupe's latest play that's available. This is Lone Star Community Radio, Conroe's 104.5 FM and 106.1 FM community station. Find us on the web at irlonestar.com. Lone Star Community Radio is a supporter to the performing arts in Montgomery County, Texas.
A Lone Star Community Radio is looking for those who are interested in hosting their own talk show, with monthly and weekly slots available on Conroe's FM 104.5, 106.1, and on irlonestar.com. Start your own podcast, create your first YouTube channel, and be on TV. Contact Lone Star Community Radio online at irlonestar.com or call the station message line at 936-647-3776 to take your first step into the radio world.
Welcome back to the Legal Connection with Toni and Cheryl. We are at 104.5 and 106.1 on irlonestar.com, Conroe's FM. Today we're talking about wills, and the next thing we want to talk about is a self-proving affidavit. Toni, tell us what a self-proving affidavit is.
Well, the self-proving affidavit is a provision that's attached to your will that you complete or your attorney completes that allows, that permits the will to be admitted into probate without a witness testifying to the authentication of the will.
So it just basically says that all the requirements of due execution have been met, complied with, and it permits the will to be probated?
Yes.
Without a witness there swearing?
Without the witness or one of the
Right.
witnesses saying that, yeah, I was there when she did this. Because I just recently probated a will that was executed in 1981. And lo and behold, this woman just recently died. And so she died at 82. And the will itself did not have a properly executed self-authenticating affidavit on it. And so I thought, I wasn't really quite sure where I was going to go with this because I needed to find the witnesses. Well, for sure, one of the witnesses died, and it took me forever to find that she died. I had to go through all these records and the death indexes with the federal government and find out that she had died. So then I had to find the other witness, or else this entire state was going to go intestate.
Oh, dear.
And the name was so common. It was like, Jane Doe. It was like, how am I going to find, it was, almost 40 years later, how am I going to find this witness? And the will was very, very important because it was the way that this woman had set out for her assets to be distributed was not the way it was set out in the, by the legislator in the intestate code. And I want to say I probably called maybe 50 people out of 250 list of the same name. And I found this woman, and it was a miracle.
Good for you.
That she was still alive.
That's dedicated legal services.
Yes, I was determined to do the right thing by my client, and I found her. And I had to quiz her. It wasn't like, oh, by the way, she didn't know who I was from Adam. I was like a sales call, and found this woman, and she was really with it for someone that was in her 80s. And she knew more about the decedent than even her sons did, which was very interesting. And of course, they were the heirs. And but had I not found her, this will could not have been properly admitted into probate, and we would have had to go
Good
through
for
intestate
you.
law. So that is why it's so important to have that self-authenticating affidavit on it, or or write it in your own handwriting, which you don't need the self-authenticating affidavit if you have a
holographic wills.
holographic will. And what we touched on before was on our break was that you can also have an oral will, like if something happens and you're in a car accident, and you can actually tell somebody how you want to, like your will, I'm dying, and just make sure, tell all my loved ones, like the plane's going down or whatever, tell all my loved ones on your cell phone or whatever, that I'm going to miss them, then I'll see them, at the pearly gates at St. Peter or whatever. But you need witnesses for that. And what if it's the kind
Plane
of thing,
crash, like you just said.
Yeah, so it's just better to, if you want to for your property to go by virtue of will, you can either write it out or have it done properly through an attorney or with one of the packets, as long as you do it properly, and also have the self-authenticating provision on there if by chance you live a really long time and your witnesses are no longer alive.
Yeah, that's a good point. What about the packets? I mean, I'm suspicious of the packets because I know in Texas we have, they give more credence to what's written than what's typed, and like in a fill-in form thing, and to me, it just seems so iffy.
Well, you can't practice law. So you and I could do a packet because
Right.
we could, and you can do it for yourself. Just like with you, if you have real estate, you can buy or sell your own property without, there being any issues of whether you can change something in the provision, like the broker's contract legally or what have you. But with the actual packaged wills, you take a risk if you buy the packets. I've seen them; they're actually pretty good.
Yeah.
But I've also seen people that have brought the wills to me that have been completed through like LegalZoom.com or
Right.
like the little ones that you buy in the bookstore. I don't think anybody buys things in
Or
bookstores
Office
anymore.
Depot or something.
Just the actual, the few pages that you get, or if you
Right.
download it from the internet. The problem is if you don't do it right, it's not going to be, it won't work. It's not valid. You can't get it
Right.
probated. So you could probably fill it out and maybe save yourself a little money if you fill it out yourself and then have an attorney review it. That may be one way to save some money. I know a lot of people have done that. That's why I still, even as an attorney, I'm just like, just write out who you want it to go to, and
Right.
don't be bribing people when you're really old, like a lot of people do, saying, I've got this
Mm-hmm.
ring and I'm going to give it to you if you're nice to me or whatever. And
When I die, y'all can decide.
yeah. Now, I know that we learned this in wills in the probate class, that there's a lot of ways to contest even a properly executed will. There's going to
Absolutely.
be undue influence, whether the person had capacity when they signed it.
Right.
Because a lot of people that are the survivors, they want the property and they're going to try to contest it. I actually have a will contest. It's not actually a will contest. It's an adversarial case in probate court going on right now, that brings a lot of different aspects of defenses and arguments, affirmative defenses, on why a will is or isn't correct or valid in the way that where someone's arguing what the decedent's donative intent was that's
Right.
contrary to the will.
The
Or-
intent that they had when they were deciding who would get their property and who would actually be the taker, the one who received,
And
what their
this
intent
this
was.
argument is the argument of ages.
Absolutely.
I mean, this is the same thing, and that's why I was bringing up Anna Nicole Smith earlier.
Mm-hmm.
I mean, she, after J. Howard Marshall died, of course, we saw her on the TV,
Constantly.
constantly. Now, for younger viewers, that they're not going to remember that. But,
Right.
the beautiful Playboy model, Anna Nicole Smith, that gained a little weight, still looked just strikingly beautiful right here in the Harris County courts, talking about how it was really expensive to be Anna. So,
I
to,
remember that.
to the very rich
It's like killing us, Anna.
sons of J. Howard Marshall, who I believe they are both deceased now too, or at
Oh,
least one of
really?
them is. So all of this happened pretty recently. So Anna deceased, her son deceased,
Right.
the guys who were fighting her deceased, and that court actually, to try to have legal maneuvering, it actually went to the California bankruptcy court, and then up to the Supreme Court. So she was just right and left trying to find a way to get to this guy's money, and ultimately, the only surviving heir was her beautiful daughter.
Right.
And I think that there may still be some activity in that case, but it's unlikely that she's going to inherit the little girl, her heir, any
Right.
of the.
That's what I understand too. Well, I know that sometimes it's to an advantage to heirs to knock out a will that is there, and this is a perfect example. And the way that they do it is they claim undue influence, that the relationship became manipulative, coercive, and
And don't you know, like in your own life, don't you know some relatives,
Oh,
neighbors
absolutely.
that
Right.
where there's somebody that like cannot, maybe they cannot not waiting for them to die, but they know somebody is getting older in age and they're anticipating maybe inheriting the form.
Exactly. Or what about people who don't have good relationships with their children, and then they've got other relationships that come in, and those begin to look suspicious after the property is disposed to them. But we've got undue influence, we've got duress, which, that just means force, coercion,
right.
fraud, just flat out lying to someone, is another way you could knock a will out.
Yep.
And tortious interference with expectancy is also a cause.
Right.
That, you've got just these valid heirs, and
Are the people that really should, the donative intent of the
Right.
decedent really was something different from the way it looks like it's going down because of fraud.
absolutely.
And after our break, we're going to talk about a case that's a very important case that just the story behind it is something that a lot of people have gone through, and you'll get to see how it turned out and what the law in Texas is with regard to some of these fraudulent transfers that you can reel back in and the right thing will be done.
Well, that sounds wonderful. So we just want to remind you that we're Toni Sherritts Collins and Cheryl Ellsworth Jahani. We're two licensed attorneys in the state of Texas, and we're here to help you wade through some issues that you have, and we'll be right back with you after the break.
Our talk shows and music shows are looking for sponsors. Want to expand your brand awareness? Reach the hyper-local audience in Montgomery County? Lone Star Community Radio sponsorships accomplish this. Want to see our stats and rates? Check out irlonestar.com/sponsor for more information. Or call in and leave us a message at 936-647-3776.
Hey guys, this is Connor.
This is Dick.
This is Chris.
And we're with the Ticket Stub Podcast every Thursday live at noon on 104.5 and 106.1 FM in the Conroe area. Also, anytime at irlonestar.com. You go to irlonestar.com/TTS. You can find all of our social media.
And don't forget, we give away 2 tickets to the Grand Theater on every show.
If you like movies and you like complaining or celebrating anything that has to do with the silver screen, check out the Ticket Stub Podcast and join us every Thursday at noon o'clock on Lone Star Community Radio.
Welcome again to the Legal Connection Show with Toni and Cheryl, and we just want to remind you that we are live Tuesdays, 12 to 1 on 104.5 and 106.1 Conroe's FM in Conroe, and also you can listen to our podcast on Google Play and iTunes the following Wednesday, the very next day after 8 a.m. So we're here again. It's Toni and Cheryl, and we're talking about wills and probates and estates. And Toni, you're going to tell us about a case that you're familiar with.
Yes. And actually, it's a case that came out of Harris County, but I've seen this happen several times in other with other clients of mine. And basically, what happens is you've got somebody that's a child, perhaps, or maybe a significant other, or whoever it may be, but somebody's got their eye on the property of the person that's getting ready to die. Somebody's got some property, somebody wants it. The age-old story, right? Whether it's by a criminal, a crime, or whatever, by fraud. Well, in this particular instance, just like with Anna Nicole Smith, they're a one way to maneuver to a person that wants someone's property. Not that we're advocating this by any means, but this is what happened. If to move someone's property into a trust can be a double-edged sword. To move it into a trust, if you're perhaps the child of the person that would normally inherit, and you can see the new paramour, the new, if you're the widow, your dad or your mom has died, and they have a new boyfriend or girlfriend. If the child sees their inheritance going away, the child, just like in J. Howard Marshall's case, will come in and sort of talk with the parent and say, "Hey, we need to set up a trust." That the parent's not really. The parent probably knows what's going on, but they're like, "Yeah, we know this new person isn't here in my life to take your inheritance away. They're just to keep me company." And so everybody's on the same page, and a trust is set up. And if a trust is set up, then that is outside of the estate. That is outside of probate. Just like financial accounts many times are outside of probate. And so in this particular instance, what happened was, and I'll just tell you the story behind it, and then I'll kind of segue into how this is what could happen in a lot of other people's lives. This might help. In this case, it is Ritter v. Till, and it was a Houston case that was decided back in 2005. And in 1997, Rudolph Bittner executed a will, and he devised his farm to his niece. He was a widower. His niece was named Marianne Popp. And in 1999, the guy that executed the will, Bittner, executed a durable power of attorney, appointing his niece as his attorney in fact. And there wasn't any provisions in the particular attorney in fact saying whether or not he needed to be incapacitated. It wasn't a medical power of attorney or anything. It was just simply he gave his niece, this younger woman, the ability to determine what should be going on with his estate, whether it was to pay bills or, I trust you so much, niece, that if I've got property, you can sell it. I'm going to let you handle things while I'm off in Tahiti with my new lover the last years of my life or whatever. Okay, so that isn't actually what happened, though. Bittner had this attorney in fact. Pope, the niece, created a revocable living trust so that all of his assets went into this trust. And apparently he was fairly wealthy. He had a large farm, a lot of assets. And she was named the older man was named the trustee. So he could actually, as trustee, revoke it any time anyway. So she's kind of being, she's doing the right thing. Pope executed a warranty deed, though, as she could, conveying the farm to Bittner as trustee of the trust. So now the trust owns it. And the trust also can protect your property in the event that there's other, there's judgments or, for tax purposes or for estate planning.
People spend too much money and they're young.
So there's other reasons for trust. There may have been another reason why they actually did this. But anyway, according to the trust documents, Pope was to receive the farm at Bittner's death. The niece was going to receive it. Well, Bittner died 2 years later in 2001. And for some reason, the niece decided that she didn't want this property. Well, the niece had some children, okay? So the grandnieces, they did want it. But the mom niece, she didn't want it, and she kind of wrote it off saying she didn't want it. Well, the nephew decided he wanted it. And what it came down to is the nephew put together the nephew claimed it. The nephew said that the trust didn't exist, and the property actually is going to come to me through intestate.
What?
So, but what happened was, it says the Pope attempted to create a trust under a durable power of attorney, and the nieces didn't know how to get this property back from the nephew, the grandnieces. Okay, and he was doing everything he could to get it, and he actually got a judgment. It was like they couldn't even appeal it anymore, and they found a loophole to get back into it, which actually was completely the way it should be.
Right.
It was doing the right thing by the law. It was a loophole, so that kind of goes toward don't ever give up. All right.
Right. Absolutely.
The Texas Trust Code dictates that a trust is created only if the settlor manifests an intention to create the trust. All right. So
then the settler would have been the uncle.
The uncle, right. And because the uncle did not create it,
right, just
there
the
was
niece.
no trust.
Oh.
And so what ultimately happened in this case is that because there was no trust, the property went intestate to the nieces. It was no longer all of the default judgment and all the stuff that the nephew got. However, the nephew ended up with this through a one court process.
Right.
That all got reversed, and it went back to the intestate because the trust could not have been created by an agent. So the bottom line here was an agent acting under a power of attorney cannot have requisite intent to create a trust. Only the person that owns the property can create the trust. And that's really, really critical in a lot of ways, because if a trustee thinks any power of attorney,
this is mine, I can do whatever
any
I
power
want.
of attorney, if they're doing something deceptive or they think they're going to like Pierce Marshall, if he decided he wanted to take all of his property and give it perhaps to his girlfriend, completely out of the realm of the family. He could have done that. But here, because of the way this was set up, an attorney in fact cannot create a trust.
That's awesome. Well, since you brought that up, I just quickly want to, and maybe.
Oh, I'm sorry. One provision.
Oh, okay.
Unless the trust says they can.
Oh, right.
But here it has to be very specific, though, and statute, state law, and the statutory law does the Texas Trust Code and the Property Code does not allow you to do that. So.
Oh, okay. So they can't do it anyway.
They could, unless there was a very specific provisions within the trust contract that said, notwithstanding this trust code and this property code, this is what we mean to do, and then you might be able to get around it that way.
I see. Well, that's interesting, Toni. Thank you. Well, here we are. It's Toni Sheritz Collins and Cheryl Ellsworth Jahani. We're two licensed attorneys in the state of Texas, and we're bringing you the Legal Connection, and we'll get back to you after the break.
Relax with a cup of joe or your favorite drink for the Conroe Lake Conroe Chamber of Commerce Chamber Chat. The show airs on the first Tuesday of the month at 11 a.m. on Lone Star Community Radio. Join hosts Courtney Galley and Brian Bondi as they chat about the Chamber's events and programs for the month and invite Chamber members into the studio to talk about their upcoming events and businesses. Learn about your Chamber with Chamber Chat every first Tuesday at 11 a.m.
Lone Star Community Radio is looking for those who are interested in hosting their own talk show. With monthly and weekly slots available on Conroe's FM 104.5, 106.1, and on irlonestar.com. Start your own podcast, create your first YouTube channel, and be on TV. Contact Lone Star Community Radio online at irlonestar.com or call the message line at 936-647-3776 to take your first step into the radio world.
Welcome back to the Legal Connection with Toni and Cheryl. We're here answering your questions and addressing legal issues to help the citizens and the community of Conroe, and we're on Conroe's FM 104.5 and 106.1. Also, we want to say that you can listen to us live on irlonestar.com/TLC on Tuesdays from 12 to 1, or you can listen to the podcast the following Wednesday at 8 a.m. We're on Google Play and iTunes. We're talking today about wills and probate and trust. Toni just talked to us and gave us some good education about trust and basically what they are and how they can be effective and ineffective. And, Toni, I just think that any discussion about wills and probates is not complete until we talk about advanced directives. I had someone the other day say, well, the thing that matters is the will, not the advanced directives. Advanced directives are something that you create in the event you're incapacitated, you're on life support, you have dementia and you can't make decisions for yourself. And this person said to me, what really matters is your will. And I said, well, yeah, if you die. But if you don't die, what really matters are your advanced directives, don't you think?
Very much so, because you could be like in a vegetative state for years.
Absolutely. And if you haven't made clear what you want, then what's going to happen is those that are closest to you, and there's some default go-to people, your spouse first, and then your oldest child, something like that. I can't remember, but they are going to make decisions for you that may not be your decisions. And
may not be decisions of the people that really care for you.
Absolutely.
And somehow it defaulted to somebody that's really, for the love of the money, doing the wrong thing, which happens quite a bit.
Right. And so as far as advanced directives are concerned, just quickly, we've got, you'll need a HIPAA release. Any attorney can draw these up for you. I don't suggest personally, I don't know what you think, Toni, but I don't suggest that you would try and draw these up yourself, but I just want to give you a quick run through of what is in them. You've got a HIPAA release form that's going to allow whoever needs to get your protected health information that you've already signed and had notarized. You're going to have directives to physicians, and those are going to tell you whether you're going to be on life support, what you want to do. Do you want to be on life support or not? Or my doctor and I will make it together if I have capacity. If I don't, then I'm going to give medical power of attorney to my agent, my attorney, in fact, who will make medical decisions for me. Now, that's different than durable power of attorney. I don't know if you guys know this or not, but these are revocable.
And I'm just going to say something. I'm just going to jump in real quick. It's really, really important that the person that has your medical directive, that you really trust them and they're really looking out for what's best for you, not just somebody that's manipulating your life or whatever, or, just trying to get, because this person may be someone who's inheriting and they don't want you to be around a lot longer.
That's unfortunately
because
true.
If you want, you may want CPR. I want to stay alive because it's a gift. I want to stay alive with for every breath that I can get during as long as I can. The person that may not be looking out for your best interest that has your medical directive can give them a do not resuscitate, a DNR.
They sure can.
And you may very well have told everybody you know, please give me CPR. And this person is the instant that you may not even be out of it. You just may be given drugs for pain. They're going to go try to find some way so that you're not resuscitated and capitalize on your demise.
Right, absolutely. So medical power of attorney is a big deal. Durable power of attorney does not address the medical issues. Those are like they can handle your real property like your home, your land. They can make decisions with your personal property, your stocks, bonds, estates, retirement transactions,
However,
tax matters.
a durable power of attorney can have a provision in it that it becomes effective upon your being disabled or incapacitated. And there is, and if it's not defined, and they're usually not in these little canned forms that you get in the bookstore, not the bookstore anymore, but on the
Online,
internet,
right.
there's actually a statute that provides, and I believe it's, I had it written down, there's a statute that provides for the definition, it's the Texas Estates Code, of what has to happen, what condition precedent has to occur before you're determined to be disabled or incapacitated.
Right, absolutely.
Which is very, very important because you may not be, and somebody's going to say you are, so they can get your property.
Right, it needs to be clearly spelled out, like you were just saying.
Just very specifically, you have to have a physician examine you and certify that you are incapacitated because you just may be on pain drugs.
Absolutely. And then also another form is a declaration of a guardian in the event of you're later incapacitated, and the appointment for the disposition of your remains. Some different religions, that may be important to them. And then we go to the will, which is what we've been talking about this afternoon with our listeners. So I just wanted to talk about the advance directives. I think they're just as important.
I think it's critical because I have a case right now where, very importantly, there's an argument as to whether the durable power of attorney became effective. And, of course, my position is it did not because there was never any certification by a physician at any time that this person was incapacitated. However, the attorney, in fact, went ahead and said, do not resuscitate. Pretty much transferred her body transferred her when she was sick without having any biopsies or treatment done to find out what was wrong with her, transferred her out of the hospital, and then she got pneumonia because they didn't take care of the problem that caused her illness, and she died. And now he created a trust 3 days before she died and is now saying he owns everything.
Oh my
So
goodness.
really bad things can happen if you're not really careful about who you trust and getting it done properly with an attorney looking at it, but also just making sure that you really know the people that are close to you, so that they're doing the right thing. They have a power of attorney actually creates a fiduciary duty. The person that has that has to do what's right for you, has to do what's right in
your
good faith,
best interest.
and if they have your power of attorney. And a lot of people just don't do that because we all know the love of the money is the root of all evil. And so that is why you go to court, because you think everything's fine.
I know.
And it's such a loving family, and then you see all the pictures of the babies and stuff, and then they're older, and then all of a sudden it wasn't that way at all. And so you just have to have a prayer. You have to pray for this whole family, and wherever they're looking down, they're thinking, just take care of it. I'll see you soon, and
that's right.
that kind of thing.
Absolutely. Well, Toni, this has been great. This has been our first show. We got to talk about wills and probate and trust. We're going to be on this is January the 30th, but we're going to be on next Tuesday from 12 to 1 at irlonestar.com/TLC, February the 6th at the same time from 12 to 1 p.m. So you can listen, our listeners can listen live. And
we're also going to be taking questions. So the majority of the questions that we get on our website, that will be the topic that we cover for that particular segment or that week. And we'll try to get to the public's questions to answer a lot of things about DWIs. Maybe you got charged improperly with an assault. That happens all the time. Child custody, child visitation, child support.
Right.
All those issues that come into everybody's daily lives, we'll be covering those issues. But you have to give us the questions on our website so we know how to help you.
That's at legalconnectionshow.com/contact/ and also, and then you tag questions at legalconnectionshow.com. And so I've had a great time, Toni. Thank you. This was great.
Yes.
We look forward to next week.
Yes.
Y'all have a blessed week.
TLC. You need
right.
it.
Absolutely.
Thank you for checking out this production of Lone Star Community Radio. Lone Star Community Radio is Montgomery County's community radio station. Don't forget to check out this show and many others across the Lone Star Community Radio Network, either live on Conroe's FM 104.5, 106.1, the Lone Star Internet Radio app, or irlonestar.com's live audio stream, and on replay on podcast, Channel 12's Our City TV in Conroe, or Channel 21 KVQT in Houston, and of course their YouTube channel. This production is copyrighted and all rights are reserved by Lone Star Community Radio. Have a question regarding this program or other Lone Star Community Radio shows? Want to sponsor or start your own show? Call the station message line at 936-647-3776 or email the station at lscrstudios@gmail.com.